Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis.
Get ready without any stop. Shri Rajesh Goyal has submitted that the petitioner was a degree holder in a suit for specific performance, and when the defendant judgment debtor failed to execute the sale deed of the land in question, the executing court executed the sale deed on 8/5/1992 and sent the sale deed for registration before the Sub Registrar Meerut. The Sub Registrar found that the sale deed was executed on stamp paper of rupees 22,000, but in accordance with the circle rate determined by the District Magistrate, the value of the land in question would be rupees 1,80,000, and hence the stamp duty chargeable would be rupees 26,000. As such, the executing court, on the report of the sub-registrar, found deficiency in the stamp duty and required the decree holder petitioner to deposit the same before the executing court. According to him, the rules framed under Section 47 of the Stamp Act have provided a clear procedure for determination of the value of the land in case of dispute with respect to payment of stamp duty. He submits that the collector has jurisdiction either suo motu or otherwise to satisfy himself with respect to market value of the property in accordance with the procedure prescribed under Rule 340 of the Stamp Rules 1942 as were applicable in the year 1992. He states that having not initiated the process for valuation of the land in question for the purpose of payment of stamp duty on the instrument, the executing court has committed an error, since it ought to have directed the district magistrate to do so when there was a dispute. Shri Goyal has submitted that in case of an order passed by the collector demanding deficient stamp duty, the same would have been appealable under the provisions of Stamp Act, but when the civil court in execution of a decree of specific performance has passed the order to deposit deficit stamp duty, no appeal can be preferred by the petitioner in case he is aggrieved by the demand of excess stamp duty. Submission, therefore, is that the petitioner has been deprived of a forum of appeal against the demand of excess stamp duty on the one hand, and on the second, the demand being based on circle rate cannot be taken to be an absolute determination of the market value. The aforesaid submission of Shri Goyal appears to have substance. The Revenue Authority has not noticed the petitioner for a deposit of deficient stamp duty. In fact, it has written to the executing court for payment of deficient stamp duty, and the executing court has directed to the petitioner to deposit the same so as to stamp the sale deed and satisfy the decree for specific performance. Therefore, the right of appeal under the Stamp Act, if any, to the petitioner has been taken away. The second submission also appears to have force, inasmuch as by the impugned order passed by the executing court, the valuation has been found on the basis of the circle rate determined by the district magistrate.